One for Fred Komondi, Paul Kandi Chumo, and for Evans Rogue and Dambi. These certificates were purported to be issued by University of Nairobi. According to Evans Mwinzi Mbuva, in the letter dated 3rd of July 2019, next, number 3 confirmed that the certificate for fees and Ocheng, Omondi, Fred Komondi, and Paul Kandi Chumo, and Evans Rogue and Dambi were forgeries and not originate from the University of Nairobi. The other document was, number 4 was BSc Mechanical Engineering for one part to Kimani Gitonga. The same was found to be a forgery by Dr. Esther Dara Moria, PW10. Uru produced the letter exhibit number 65. By the Dara accused engineer Luka in his capacity as chief officer and the AE holder for the Department of Roads, Transport, Public Works and Utilities. The payment vouchers for that sum are 20 AC, 21, 22, 23 and 24. The county government of Kiambu, the second one, the second payment, made payment to Testimony Price Limited in risk of work done for a total sum of 88,454,222. These are reflected in the 4 payment vouchers, 25, 26, 27, and 28. Mr. Mohammed stated that the total sum paid to Testimony Price Limited on account of the tender for the road construction was a sum of 147,273,555. He also added that beside the payment for that road transport tender, Testimony and Price Limited were paid through contracts under requests for quotation a total sum of 74,216,944.80, as shown by the following payment vouchers: 29, 30, 31, 32, 33, 34, 35, 36, 37, 38, 40, 41, 42, 43, 44, 45, 46, 47, 48, 49, 50, 51, 52, 3, 4, 5, 6, 7, 8, 9, and 60. The sums are shown. At the trial, the lead investigator contended then that a sum of 221,490,499.80 cents was laundered to companies and entities owned by officials of Kiambu County government from the payment under the questioned roads project tender and the request for quotations. The investigation prepared the investigators Yes, the investigating officer prepared a flowchart of movement of funds from Kiambu County government to Testimony Enterprise Limited and ultimately to companies owned by Mr. Waititu and Susan, producing evidence as plaintiff exhibit number 146. The flowchart is supported by checks and transfer of funds and payment vouchers. These documents are now producing evidence as exhibit number 96 to 101 to 108 and 111. The following documents produced as exhibit were relied upon by the prosecution to support the movement of money. Exhibit number 121, transfer of land to Superior Phone Communications, to Saika2 Developers Limited, the purpose was then stated, for that was stated to be the transfers to established payment made by Testimony Enterprise Limited to Saika2 Estate Developers Limited. Transfer was then signed by Director of Superior Phone, Rahab Muyaki Karoke and Winnie Wambui. And on behalf of Saika2 Estate Developers, the transfer was signed by Mr. Waititu and Monica. Exhibit 120, sale agreement between Superior Phone Communication Limited as vendor and Seka2 as purchaser. Agreement again signed by Mr. Waititu and Monica. After the conclusion of the investigations, Mohammed recommended the charges preferred by the Director of Prosecutions against the accused person. At the trial, the lead investigator produced evidence corresponded by ESCC, inventories for documents recovered, application for search warrants and orders, specimen signatures and directing of suspect and exhibit memo forms referred to in his evidence. This is the defense case. The former governor of Kiambu, Mr. Waititu, chose to give sworn evidence and called Winnie Wangeshi Mainda, alias Elizabeth Wangeshi Mainda, DW2 as his witness. He testified that he was a businessman dealing in land speculation and admitted that Testimony Enterprise Limited and its directors, the fourth and fifth accused person, were known to him for over 15 years. It is the defense by first accused person that the fourth accused Chege approached him to buy parcels of land, Nairobi Block 105, 8850 and 8851, along the Eastern Bypass, and that the sale price for each parcel was agreed at the sum of 50 million. The first and fourth accused person relied on the sale agreement, which is dated the 3rd of January 2018, producing evidence as for the defense as D1, exhibit number 1. He then used the sale transaction to counter the allegation regarding the monies paid by Testimony Enterprise Limited and the fourth accused person to Seka2 estate developers, Seka2 Estate Developers Limited and Benvenue Delta Hotel. He claimed that as at the time of selling the two parcels of land to the fourth accused person, the title deed had not been processed and that he was unable to transfer the properties because of a caveat that was led by the ESCC. The former governor testified that he justly earned his wealth from businesses and a long political career, where he started as a councillor and rose to the position of a deputy mayor, an MP, and eventually a governor. He also testified that he had served as an assistant minister. It was also the evidence of the first accused person that this case was a result of political witch hunts after he aligned himself with the Tanga Tanga political wing during the 2022 general elections. And according to him, this political choice, which he had made, caused him to be charged with the corruption offenses and also to be hounded out of the office of a governor. He attacked the process leading to his impeachment before the Senate, a matter that is not for this court to consider. I won't have to whether the Senate is right or wrong. That one I may not know. I do not have jurisdiction over that. First accused person admitted that Benvenue Delta Hotel was part of his business, owned together with his wife Susan, and he explained the impugned transfer of money to Benvenue Delta Hotel by stating that the said Chege and his company, Testimony Enterprise Limited, were customers of the hotel. The former governor further said that his wife owns Lexo Petroleum Giro Shopping Center and a fuel transportation truck, and that when Chege won the tender in question for the road project, the wife used to supply him with fuel. He claimed that the payment made to Benvenue Delta Hotel were for oil and petroleum supplied. First accused person also testified that he rented a shop to Charles Chege at Jamimbora building, who paid a goodwill in the sum of 3.4 million. First accused, in contrast, the evidence by Rab Muhakaroki, denied that the fourth accused, Charles Chege Mbudia, paid money to Lake Naivasha Resort Limited on his behalf and alleged that Chege was a tenant of Rahab. In the end, he produced in evidence the following document in support of his case. D1, Exhibit 1, the sale agreement D1, Exhibit 2, the title deed D1, Exhibit 2.1, lease D1, Exhibit number 2, C1, power of attorney, D1, Exhibit 3, title deed D1 Exhibit 3.1 title deed. On cross-examination, first accused admitted that he received the sum of 18,410,500 from Testimony Enterprises Limited, which comprises of 12,410,500 received by Sekatu Estate Developers Limited, and he also admitted that Testimony Enterprises Limited transferred a sum of 7,214,000 to Benvenue Delta Hotel, and in re-examination, he insisted that the sum of 18,410,500 received from Charles Chege and Testimony Enterprises Limited was part payment for the sale price of the parcel of land, the subject of the sale agreement dated 13th of January 2018, then produces exhibit number D, exhibit 1. And on further cross-examination, Mr. Waititu persisted to assert that he was not aware that Testimony Enterprises Limited had transferred a sum of 6 million to Lake Naivasha Resort. The witness for the first accused, Elizabeth Wangeshi Mainda, testified in support of his case that she had sought to win the 2 parcels of land, 10 Block 1 of 5, 88, 50, and 51 along Eastern Bypass. Under the trial, she relied on the power of attorney dated 7th of November 2014, donated by children, to sell the plot from which the 2 parcels of land were hived and registered. That power of attorney was D1, Exhibit 2C1. Susan testified that she was married to the first accused person for that 4 years, and that during the subsistence of the marriage, the couple has been running business together. She testified that Testimony Enterprises Limited was a client at our hotel, Benvenue Delta Hotel, and made payment through the hotel account. On cross-examination, she admitted that the business name Benvenue Delta Hotel was jointly owned by herself and the husband. She further testified that Benvenue Hotel was a tenant of Sekatu Estate Developers Limited, and on further cross-examination, she confirmed that the business name Benvenue Delta Hotel had received the following payment from Testimony Enterprises Limited and Charles Chege. The funds transfer, 99C1, funds transfer, 99, I think I'll check on that one. I'm not sure whether I marked the one for 2 million. I check on the marking, whether it's 99C1, both of them, I'll check on that. Check 97C4, check 97C5, check 97C, two. There should be 97C. Okay, 97C11. I'll also check on that. Eugenia Luka Mwangi Wainya was D3. He admitted that was the Chief of Department of Road, Transport, Public Works and Utilities, and endowed with the responsibility of an accounting officer and the IOLA at the Department of Roads, Transport and Public Utilities. He acknowledged that he was familiar with the tender in question and played the following roles: budgeting, preparation of departmental procurement plans, initiating the tender document work, appointment of the tender opening committee, appointment of tender evaluation committee, review of professional opinion, award of tender to Testimony, issuing of notification letter to Testimony, forwarding acceptance letter for tender to Testimony and to the county attorney for preparation of the contract, signing of the contract, which is X number 61, appointing project implementation team led by the engineer, PW 15, and then it was the signature of the payment vouchers, being the chief officer for that department. which is borne out by the 7 certificate for a total sum of 147 million. On cross-examination, that accused was referred to the tender bin document, exhibit number 8 at page 29 of 213, section 5, bearing the subheading qualification criteria, and considered that serialization and form of tender were not criteria. These two criteria were the main concern raised by the head of procurement, Dr. Bundi, PW1, the professional opinion, exhibit number 14. In re-examination, that accused admitted that serialization form of tender was omitted in the tender, that these two criteria were mandatory statutory requirements under the Public Procurement and Asset Disposal Act. He denied that no due advantage was given to the company Testimony Press Limited. To testify for the defense was the fourth accused, Charles Chegambudia, Director of Testimony Press Limited. He learned about the tender in question from an employee, one Joshua Kazungu, and instructed him to be exhibit number 9. He admitted signing the contract, produced as exhibit number 61, together with his wife, Beth Wangeshimburu. Chege then produced in the minutes of Testimony Press Limited, D5, exhibit 1, but contention that the wife was least involved in the matters except for her role in the signing the contract, exhibit number 61, as a co-director of Testimony Press Limited. He added that he was the sole signatory of Testimony at Equity Bank as evidenced by the letter dated 30th of April 2018. Chege acknowledged that he received a sum of 58,819,083 and 28 cents being advance payment for the tender in question. Chege supported the evidence of the second accused, Susan Wangari, that he paid a sum of 7,214,000 to Benvenue Data Hotel for outside catering services and conference facility to train and hold the meeting with his staff. He also supported the defense by first accused, Mr. Waititu, that on that of January 2018, he entered into a sale agreement to purchase parcels of land, Nairobi Block 105, 850 and 851. He then made the following payment to the first accused person, to the first accused person's company, Sekatu Estate Developers Limited. The payment of 13th March, 5th October, all those payments. So the above payment is supported by a band of 10 receipts, produced in evidence as D5, exhibit number 41 to 10, and the agreement dated 3rd of January, produced as D5, exhibit number 5. Chege admitted that Rahab Muyaki, the proprietor of Lake Naivasha Resort, was well known to him for over 20 years. He had paid a sum of 6 million to Lake Naivasha Resort as goodwill for shops A and A2 on ground floor of Delta Hotel, which changed to Benvenue Delta Hotel. In order to support this payment, he produced in evidence the receipt D5, exhibit 3A and B, dated 28 August 2018, issued by family signature. However, on cross-examination, the funds transfer produced as plaintiff number 97D1, dated 28 August 2018, and plaintiff exhibit number 97D2, dated 27 September 2018, narrated the purpose of the funds as a refund of a soft loan. Chege's reliance on the receipts, D5 exhibit 3A and B, and must is trickery. Thus, none of these two receipts, D5, exhibit number 3A and B, both dated 28 August and 2018, could justify the funds transfer for a sum of 3 million dated 27 September 2018, as per plaintiff exhibit number 97 D2, made after the date of the receipts. In my view, the truth on this matter rests with the testimony by the independent witness Rahab Muyaki Karoki, PW5. Narration on the funds transfer was a cover-up on the money trail by Mr. Chege and Mr. Waititu. More so, that accused conduct is a matter of interest to this particular court. It was discreet enough. That's the fourth accused person. That's Chege. His conduct in this matter is of interest to this court. I note that he was discreet enough and avoided to produce these receipts when Rahab was giving testimony. On further cross-examination, Chege admitted that on 26th of February 2018, he had signed the bin document for the following for Testimony Press Limited. That's plaintiff exhibit number 9, and attached the following documents. Many of them, they are the question degree certificates, which were held to be forgeries. The sixth witness was fifth accused, Beth Wangeshi Mburu, co-director of Testimony Press Limited, wife to Mr. Chege. A brief testimony was that the husband took her to Kiambu County Government offices to sign the contract, exit number 61. It was a contention that she was not actively involved in the running of Testimony and Press Limited and on cross-examination. She acknowledged that Testimony and Press Limited won the tender in question, and on further cross-examination, Beth admitted that on that 1st of May 2018, she had received a sum of 500,000 from the bank account of Testimony and Press Limited. That is per plaintiff X number 97B. This to suggest that Beth was both at a personal level deriving benefit from the funds earned by Testimony Enterprises Limited. Party submissions are as follows. Prosecution filed submissions dated 6 November 2024, highlighted by Mr. Monda, Assistant Director of Public Prosecution. Gist of prosecution submission was that 11th accused, Testimony Press Limited, co-owned by 4th accused Chege and 5th accused Beth, was unlawfully awarded by the 3rd accused Engineer Luka the tender in question for upgrading various roads in Kiambu County to bituminous standard. Prosecution blamed the 3rd accused for ignoring the professional opinion, XB number 14, by the head of Procurement, which had faulted the tender evaluation committee for introducing 2 new criteria, namely serialization and form of tender in the report produced as XB number 7B, thus giving undue advantage to Testimony Enterprise Limited against the other 4 bidders. In addition, the accused was faulted for improper use of office to unlawfully confer benefit, which is the award of tender to Testimony Enterprise Limited. Testimony Enterprise Limited was also blamed for the procurement fraud for relying on the false documents which were attached to the bid document, plaintiff X number 9, and unlawfully acquired a sum of 147,274,055.40, the man's public funds from the Kiambu County Government. It was submitted that first accused was the duly elected governor by dint of that position and agent of Kiambu County Government. Prosecution contended that funds flow charts produced as plaintiff X number 146 demonstrate that substantial amount of public funds paid to Testimony Enterprise Limited from the tender in question were ending the account of the 12th accused, Saikatu Estate Developers Limited and Benvenue Delta Hotel. Prosecution further submitted that the public funds channeled by Testimony Enterprise Limited through Saikatu Estate Developers Limited Benvenue Delta Hotel and direct funds transfer were used to acquire the property Delta Hotel from Lake Naivasha Resorts. Thus, it was submitted that first accused had acquired an indirect private interest in the public funds paid to Testimony Enterprise Limited. In a rejoinder to the defense raised by first accused person and the second accused person as well as the 4th accused person for the payment made by Testimony Enterprise Limited to Saikatu Estate Developers Limited and Benvenue Delta Hotel, prosecution submitted that the evidence by accused person and the evidence relied upon were contradictory and untenable. An example pointed was the power of attorney W2 by her children, produced as D1 Exhibit 2C, registered on 27th of April 2018. Whereas the sale agreement for the purchase of the parcel of land, Block 105, 8850 and 8851 by Mr. Waititu and Chege was entered on that of January 2018. The agreement, you can see the dates, shows that the power of attorney came long after doing the agreement. Another example given by the prosecutor was the obvious contradiction of the purpose of the funds, narrating the funds transfer and received relied upon by Mr. Chege in the defense. Lastly, prosecution urged the court to find that the charges against the accused person and the juristic person, that's the companies, were proved beyond reasonable doubt. These are the accused person's submissions, which are dated 27th of October 2024. The same highlighted by Mr. Swaka. Thrust of first accused defense and submission of that this case was a result of politics. It It was Council's contention that there were gaps in the prosecution case in view of the decision. In ASEC petition number E003 of 2022, the petition before the High Court was prosecuted by the 6th to the 10th accused person, that's members of the Tender Evaluation Committee, and resorted to their discharge in the present case. Counsel argued that there was no link to connect. It was submitted that the prosecution case was based on suspicion, which in law cannot form a basis of conviction. On this proposition, Counsel sought to rely on the case of Joan Chebisawe versus the Republic. However, in my humble view, this case was neither a matter of circumstantial evidence nor based on suspicion, as was discussed in the analysis of the evidence. Thus, the other case of Rex versus Kipkeringa Rapkoske and Joan Chebisawe stand distinguished and are not applicable to the facts and evidence in the present case. She also further submitted that payments made to Testimony Press Limited by Kiambu government were for works done. And in closing, Mr. Swaka submitted that the accused persons were innocent and that this court to acquit them. Ms. Kimani, advocate on behalf of the other accused person, adopted submission by Mr. Swaka and the earlier submission which had been tendered to Mr. Okeo at the halftime stage of no case to answer, and that this court to acquit the other accused person too. The issue for determination according to me, is whether prosecutors prove the charges against the accused person beyond reasonable doubt. In addressing this issue, I shall now proceed to analyze the prosecution evidence, the defense raised by the accused person, and submission under the following headings. The first heading will be on the burden of proof. Second, on the background for the tender in question for upgrading various gravel roads to bituminous stand in Kiambu County, that procurement process, and award of tender for upgrading the various gravel roads to bituminous standards. The money trail, the quagmire of conflict of interest, and a determination on the charges. So those are the three sub-headings addressing the determination by these courts. This being a criminal trial, it is now settled law that the burden of proof is on the prosecution to prove every element in the charges beyond reasonable doubt. That's the burden. It is the law that accused persons do not have any burden to prove they are innocent, no matter the charges. And this principle is well established in the celebrated case of Wilmington versus DPP, 1935 SC 461. That's often quoted locally. It is also trade law that proof beyond reasonable doubt does not mean necessarily proof with certainty. That is as per the decision of Miller versus Minister of Pensions, and 1947 All England Law Report at 372 to 379, decision by one of the distinguished judges in England, Lord Denning. This is the standard of proof that this court will apply in the evaluation of the evidence presented in this case. The onus, again, to discharge that burden of proof rests on the prosecution, as is the law under provision section 1071 of the Evidence Act, that whoever desires in court to give judgment as to any legal rights or liability, depending on the existence of facts, which one asserts, must prove those facts. Then controverted evidence, John Gadigi Mugwe, PW5, a former county executive committee member, in charge of the Department of Road Transport, Public Works and Treat as the Kiambu County government, presents the origin of the idea to use new methods to make roads, which was mooted by the governor in January 2018. He initially undertook the research and became aware of the Road Standard Circular number 1 of 2016, exhibit number 90C, which was forwarded by the Principal Secretary Minister of Devolution to the Chairman Council of Governors. He also forwarded the circular to sub-county engineers and the other accused person. The chief of also made the comment on the draft cabinet paper and wrote the email dated 30th of January 2018, plaintiff exhibit 92 to Engineer Luka and Mr. Karanja. And on 30th of January, he wrote the email exhibit number 94 seeking advice from Martin Jogumbugwa, the cabinet secretary, when the cabinet paper was to be tabled. This was the last time that John heard about the matter, since there was no reply from the cabinet secretary. He was never availed the opportunity to table this cabinet paper before the County Executive Committee for discussion and approval. Evidence by John is corroborated by Martin Jogumbugwa, that's the cabinet secretary, and supported by the unsigned cabinet paper for proposed improvement of county roads to bituminous standard using soil stabilization, producing evidence exhibit number 92A. To me, this marked the first start of the question tender, which was advertised and awarded without approval of the County Executive Committee. It is important to observe that the County Executive Committee approval was a fundamental stage, forming the initial stage of requisition for the tender on behalf of the resident of Kiambu County, the ultimate beneficiary of the road project, and on whose behalf both the governor and his executive committee were exercising delegated authority. To restate this matter differently, in the absence of the County Executive Committee approval, requisition, which is a fundamental step in procurement, was skipped. The safeguards then, which had been cautioned in the Ministry Road Circular number 1 of 2016, plaintiff Act number 90R, were trashed with the aftermath that personal interests were then at play. The architects of this criminal scheme and their roles will then be unveiled in the next heading. So I move forward to the next heading, the procurement process and award of tender. Notwithstanding the omission of the table, notwithstanding the omission to table the cabinet paper 92A before the County Executive Committee for approval, Engineer Luka instructed Engineer Peter Karanja Jenga to PW15 to prepare the bin document, plaintiff exhibit number 8, in respect of the question road project tender. Next, the tender was advertised. The advertisement is confirmed by the advert contained in the Daily Nation paper of 10th February 2018 and Business Daily of 12th February 2018, produced as plaintiff exhibit number 3A and B. The primary document on the criteria for the tender was the bin document, plaintiff exhibit number 8, uploaded by the prospective bidders from the Kiambu County Government website, www.kiambu.go.ke. The criteria is related to page 29 of the bid document. And I'll not repeat the criteria again, you'll be able to see it. The other accused, Engineer Luka Wainya, admitted the role of the committee and the tender evaluation committee. Up to that stage, all seemed well until the tender evaluation committee made its report dated the 5th of February 2018, as per plaintiff exhibit number 7, should be 7B. 7B, signed by the 6th, 7th, 8th, 9th, and 10th accused persons. Those are the tender evaluation committee that were discharged. The tender evaluation committee members report at page 3 under the subheading responsiveness. Based the evaluation on the 10 criteria which are produced below. I've put in those criteria and be able to see them. And on careful comparison of the bid document, that was the primary document for the tender, exhibit number 8, and the tender committee evaluation report, exhibit number 7B. 2 new criteria were then sneaked in at the tender evaluation stage, that is serialization and form of tender. This led credence to the observation by Dr. Justus Mbundi Kinoti, the head of procurement, in his professional opinion about these 2 criteria. These newly introduced criteria resort to undue advantage to Testimony Enterprise Limited over the other 4 bidders and was the only successful bidder at the primary evaluation. The star prosecution witness, Mr. Mbundi, correctly observed that the introduction of the 2 new criteria meant that bidders were evaluated on a new criteria which they were not aware. Gravamen of Engineer Luka defense against the charge of abuse of office was that Serialization as form of tender were mandatory statutory requirements under the Public Procurement and Asset Disposal Act 2015. This argument is self-defeating and is discredited by the engineer's failure to observe the due diligence in the preparation of the bid document and lack of fairness by disregarding the professional opinion by the head of procurement, which was within his mandate. The head of procurement, evaluation of the tender by the same committee or a different committee in accordance with provision section 46(4)(d) of the Act. This was the opportune moment to correct the anomaly pointed out by the head of procurement. The summary rejection of the professional opinion is contained in the there accused handwritten notes in blue ink bearing the words due procurement process had been followed to the letter. Few issues noted above cannot affect the outcome even after evaluation, and therefore I hereby award the tender to Messrs. Testimony Enterprise Limited, quote, and head of court, words of the accused person, Engineer Lucas. The same was also, these remarks being the there accused was confirmed by the document examiner, Stephen Yego, as the author of these remarks. It is apparent that there accused failed in his duty. That's under Section 94(3) of the Act, which demands that an accounting officer, in making a decision to award a tender, shall take into account the views of the head of procurement and assign professional opinion. Instead, Engineer Luka opted for a casual and summary rejection of the professional opinion, XB number 14. In petition number 3, the matter that was before the High Court, the learned judge rightly observed that Engineer Luka was to blame for disregarding the head of procurement professional opinion and awarding the tender, instead of remitting the bid bonds for re-evaluation according to Section 46(4)(d) of the Public Procurement and Asset Disposal Act. In that decision, the learned judge held that to charge the petitioners for doing what was required of them under the law, while not preferring charges against the accounting officer who approved the tender despite the adverse comment of the head of procurement and without remitting back to the petitioner to address those concerns, is an abuse of the court process. I agree with those remarks by the learned judge, but only point out one outstanding factual issue, which, with a lot of humility, I wish to correct, which was the misapprehension that the accounting officer was not charged, yet indeed the accounting officer was before this court facing charges. And that is Engineer Luka. Certainly, the engineer was the responsible accounting officer, and was charged together with the members of the Tender Evaluation Committee in the present case, but under separate counts. Nevertheless, it is my view on the matter before the High Court and the matter before this court, every case must then rest on its facts and circumstances. So I'll only deal with this particular case on the circumstances and the facts that were presented before me. Provisions of Section 227(1) of the Constitution prescribe the principle to guide state organs and public entities in the procurement of public goods, services, and adverts to a system that is fair, equitable, transparent, and cost-effective. In this case, Engineer Luka went ahead to award the tender to Testimony Enterprise Limited, and in so doing, he sidestepped the constitutional requirement of fairness, equity, transparency, and cost-effectiveness. The mischief of Engineer Luka in awarding the tender to Testimony Enterprise Limited is laid bare by the false academic certificate and letter of recommendation attached to the bid document, Plaintiff Exhibit number 9. Mr. Chege testified that he was the main director of Testimony Enterprise Limited and signed the bid document, Exhibit number 9. His signature on the same was confirmed by the document examiner, who is witness number 31. Consequently, the responsibility to prepare the bid document, Exhibit number 9, for the Testimony Enterprise Limited squarely rested on Mr. Chege. The unchallenged evidence by the prosecutors is Kazenya, Halbert, Evans, Mwenzimbova, and Dr. Esther Moria established that the academic certificate and the curriculum vitae for the technical staff attached on the bid document by Testimony were forgeries. This meant that Testimony Enterprise Limited lacked qualified professional staff to perform the road construction. The Tender Evaluation Committee and Engineer Luka never exercised due diligence in evaluating the bid document for Testimony Enterprise Limited and awarding the tender. In reality, Testimony Enterprise Limited had flatly failed the preliminary evaluation and stand guilty of fraud in procurement for relying on the Ford academic certificates. The other key criterion provided the bid document, that's plaintiff exhibit number 8, is proof of works of similar magnitude. For Testimony Enterprise Limited, it had attached on its bid document exhibit number 9 a copy of the recommendation letter dated 24th of March 2015, plaintiff exhibit number 67A, purported to have been written by Che on behalf of China Wuji Company Limited. The letter and its content are to the effect that Testimony Enterprise Limited was a subcontractor in a contract of rehabilitation to bitumen standard of Suna to Masaka Kienja C13 project. This misrepresentation was disputed by Luo Zicheng, PW 11, the deputy manager at China Wuji Company Limited. It became then evident that Testimony Enterprise Limited failed on the criterion requiring it to submit document of proof of work of similar magnitude. That's the experienced performance of the road construction works. I have no doubt that the prosecutors established that Testimony Enterprise Limited won the tender in question by deceit and procurement fraud with the aid of Engineer Luka and the Tender Evaluation Committee. In the circumstances, Engineer Luka joined the ranks of the first two architects of the corrupt scheme, which is the subject of this case. I now proceed to deal with the money trail. The money trail in this case connects the former governor, his wife, and their business entity to the corruption scheme. It is not in contention that Mr. Chege and Beth, on behalf of Testimony Enterprise Limited, signed the contract dated 16th of March 2018, plaintiff exhibit number 61. Engineer Luka signed the contract on behalf of Kiambu County government. The prosecution established that the payment made to Testimony Enterprise Limited in respect of this tender by consistent evidence on payment vouchers tendered by the accounting professionals working at the Department of Finance and the resident engineer for the road construction project. Among these professionals, Jerry Harrison, former chief officer in charge of Finance Department, Peter Karanja Jenga, PW15, senior superintendent engineer, resident engineer supervising the road projects, Joseph Kamau Dande, senior accountant in the examination section of Finance Department, Henry Buruwaweru, former director accounting services and second approver in the internet banking system, Anna Njeri, a former active director accounts and second approver in the internet banking system, Jaco Masharia Gadenya, assistant director accounting service at Finance and Economic Planning Department of the county, a first approver in the internet banking system, who mutually corroborated each other on the payments procedures as well as the processing of the payment vouchers paid in favor of Testimony Enterprises Limited. The payment process under the 9 payment vouchers in respect of the tender in question are tabulated in Table 1. We will be able to see the table. And beside the payment from the tender in question, Testimony Enterprises Limited also received payment from the various requests for quotation made in 51 payment vouchers tabulated in Table 2. We'll also see Table 2. In all the above 60 payment vouchers, the signature of the AE certificate was signed by Engineer Luka, the other accused, who was the chief of the Department of Roads. These payment vouchers originate from the department presided by the same officer. Regarding the tender, Peter Karanja Jenga, the senior superintendent engineer supervising the road project, testified that 3 interim certificates were raised by the contractor technical officer and himself. In order to confirm that the payments indicated in the 6 payment vouchers were indeed paid by the county government of Kiambu, prosecution then called Lijondi Kihima, a former senior legal officer at Equity Bank, who tendered evidence. The bank account for Testimony Enterprises Limited as exhibit number 97B. Additionally, they also called Leonard Kipseme, PW24, Senior Manager in charge of client onboarding and account service at Central Bank of Kenya, who produced in evidence the bank statement for Kiambu County Government as exhibit number 116 and as exhibit number 116. The payments to Testimony Enterprise Limited were drawn from the two central bank accounts. The payments made to Testimony Enterprise Limited in the 6 payment vouchers are shown in the following table at table 1. That's the first table. That are payment received from Kiambu County Government to the Equity Bank account of Testimony for the tender in question. Total sum 147,274,055. The second table showing the payments. These are payments under the request for quotations. Total 85,883,580. Last piece of evidence confirming the payment to Testimony Enterprise Limited is the IFMI supplier details for Testimony Enterprise Limited, XB number 126A, and the invoices 126B, which were retrieved from the IFMI system. In my humble view, prosecution evidence in support of the payment made to Testimony Enterprise Limited for the tender in question and request for quotation is sound and overwhelming. Critical part of this heading is the movement of funds after the payments into Testimony Enterprise Limited account, domiciled at Equity Bank. To entities which are associated with the former governor and his wife, as shown by the 4 flowcharts. We start with the first flowchart from Testimony to Saikatu Estate Developers. You are able to see the checks. The other flowchart shows the second one, Testimony movement from Testimony Enterprise Limited account to Lake Naivasha Resort account. The second one, the second flowchart from Testimony to Benvenue Delta Hotel. Then that Testimony to Lake Naivasha. Then the fourth chart, movement from Testimony Enterprise Limited to Charles Chege. Then funds transfers that went to Benvenue Delta Hotel as well as Saikatu Estate Developers. In summary, from these flowcharts, the payment received by Saikatu Developers Limited at Benvenue Delta Hotel from Testimony Enterprise Limited and the fourth accused, Charles Chege Budhia, who sources public fund from Kiambu County Government, is shown in table number 3. Table 3. I've summarized all that movement in that particular table. Total 18,410,500. Table 4, payment received by Benvenue Delta Hotel from Equity Bank, account of Testimony, again totaling to 7,214,000. Table 4. So that shows the money trail and where money came from and where it ended. I look at the validity of the contract for this tender. That contract is now XB number 61. The Procurement process preceding the execution of this contract is tainted by fraud. I've got no doubt about that. I've looked at the definition of fraud under the Black's Law Dictionary, which is knowing misrepresentation of truth or concealment of material fact to induce another to act to honest or to her detriment. The first issue that I tackle is that Testimony Limited won the tender by relying on forged academic certificates, forged CV, and a forged recommendation letter for proof of works of proof of similar works. The attachment to this bid document by Testimony attests to these facts. Indeed, that company lacked qualified personnel and work experience to undertake such a big road project. The second issue on it is that Testimony Limited won the tender procurement fraud perpetrated by Engineer Luka Wayenya and the Tender Evaluation Committee. The inclusion of the new criteria during the tender evaluation, to which serialization and form of tender gave Testimony Enterprises an undue advantage against the other four bidders. From the start, Engineer Luka manipulated the process of procurement contrary to Section 74(1), Roman 1 of the Act by omitting serialization and form of tender in the bid document, Plaintiff X number 8, and cunningly in his defense, despite the obvious omission, he alleged that the two criterions were mandatory as statutory requirement under the said Act. The casual disregard of the professional opinion, Plaintiff X number 14, by the engineer and the surreptitious authorization to advertise the tender when the cabinet paper exhibit number 1 was not tabled and approved by the county committee speaks volumes on the entire procurement process, which in my view falls short of the constitutional threshold that I've stated under Section 22, under Article 227 of the Constitution. Indeed, the procurement process and award of the tender to Testimony Enterprises Limited, superintended by Engineer Luka, was a mockery of the law. For all intent and purpose, the tender in question was meant to benefit Testimony Enterprises Limited, whose director was Charles Chege, and at the same time, an acquaintance of the governor and his wife. By dint of provision of Section 66(1), as read with Section 66(3) of B of the Public Procurement and Asset Disposal Act of 2015, that contract stands to be voidable. It is straight law that a contract procured by fraud is illegal. This legal proposition supported by the decision Blue Shopping Mall Limited vs. City Council of Nairobi and 3 others, which had been quoted by the prosecution. In my view, I have no doubt that that contract is illegal, null and void, and I so hold. So the same being voidable is illegal, null and void from the very beginning. I now look at the quagmire of conflict of interest. A keen scrutiny of this case, and I believe it's very important for a country like ours. A keen scrutiny of this case unearths the shadow of conflict of interest. And in my own view, that is the antithesis of good governance. That's where things are getting wrong. Thorough investigation by EACC officers exposed the money trail of public funds paid to Testimony Enterprises Limited from the question tender and the request for quotation, which ended at the doorstep of Saikatu Estate Developers Limited, and the Benvenue Delta Hotel. That is shown by the flow charts 1, 2, 3, and 4, clearly demonstrating the money trail. The end result of the money trail is that Saikatu Estate Developers Limited, a company owned by Mr. Waititu, first accused, and the daughter received from Testimony Enterprises Limited and Charles Chege Mbudia a total sum of 18,410,500. That is shown at table 3 at page table 3. I'm not certain about the page because the font could be changing. In addition, Benvenio Delta Hotel, a business name co-owned by Mr. Waititu and Susan, received from Tesmond Enterprises Limited and Charles Chege Mbuthia the sum of 7,214,000, which is shown by table 4. I'm not certain about the page. The page keeps changing because of the font, but the table doesn't change because it's derived from the statement and payment vouchers. The defense raised by the first accused person, the second accused person, and fourth accused person failed to account for the checks and funds transfer disbursement made by Tesmond Enterprises Limited and its director Charles Chege Mbuthia into the account of Saika 2 Estate Developers Limited and Benvenio Delta Hotel, as well as Lake Naivasha Resort Limited. In my view, these defenses, although conflicting, at the same time they contain an equivocal admission ongoing between Tesmond Enterprises Limited and the fourth accused person, Charles Chege Mbuthia, on the one part, and Saika 2 Estate Developers Limited and Benvenio Delta Hotel on the other part. A common version of the defense by first, second, and fourth accused person was that Benvenio Delta Hotel was providing conference facilities, lunch packs, fuel to Tesmond Enterprises Limited during the performance of the question tender. This defense by itself is an admission of the complaint conflict of interest. Moreover, the defense by the accused person regarding the services and goods supplied by Benvenio Delta Hotel to Tesmond Enterprises Limited is not supported by corresponding documents on the actual transaction. Second line of defense adopted by Mr. Waititu and Chege was an alleged land sale transaction for parcels of land Nairobi Block 105, 850 and 51. While I do not find any fault in the position that Mr. Waititu, position that was taken by the first accused person that he purchased the 2 parcels of land from the witness, Elizabeth Mahinda, the purported sale transaction between first accused and second accused person, and the sale agreement dated that January 2018 produces D1 number 1 lacks credibility. These transactions were at best afterthoughts meant to mislead this court from the truth. The first flaw in the purported agreement is the unexplained contradiction that the power of attorney or D1 XB number 2C, the plots consolidated into the parcels, the 2 parcels, is dated 27th April 2018, a date almost 4 months after the agreement dated that of January 2018, D1 XB number 1. Another glaring falsehood in the defense by the first accused and fourth accused is in respect of the sum of 6 million paid by Tesmond Enterprises Limited to Lake Naivasha Resort Limited. The truth was told by the independent witness Rab Muyaki Karoki that Chege was making the payment on behalf of Mr. Waititu for the purchase of the property where Delta Hotel was. Now Benvenio Delta Hotel. The receipt producers D5, Exhibit 3 and B were manufactured to suit the accused person's false defense. The receipts are dated 28 August 2018, meant to explain the funds transfer, as well as the receipt dated 28 August 2018, B5, X number 3B were meant to explain the funds transfer produced as X number 97D2, dated 27 September 2018, is a factual example that the accused persons were not telling the truth. You can look at the dates, and then you'll be able to see, honestly, the dates are different. If the funds transfer in September and you are making receipt even before you do the payment, the funds transfer, now how can that one be correct? In absence of credible account, for the monies received by Saika 2 Estate Developers Limited at Benvenio Delta Hotel, the only inevitable conclusion that Tesmond Enterprises Limited and Mr. Chege were remitting kickbacks to the former governor through his business entities. Constitution has placed a strict divide line for the governor to choose between public trust and business, which could lead to conflict of interest. I hold that friendship, self-enrichment, and business association are no place in public service and governance, which requires self-service, which requires a selfless service. Unfortunately, the government failed in its oath of office and allowed personal interest to supersede the public interest to safeguard public funds. He resorted to siphoning funds, public funds, into his pockets through the network of companies, Testimony Enterprise Limited, Cyca 2 Estate Developers, the Benvenue Delta Hotel. He thus joined the ranks of the trio and acted behind the covert corruption scheme evident in this tender. And I have no doubt that the involvement of the governor was concealed in a lopsided procurement process and only exposed by the overwhelming evidence on the money trail. These are my determination on the charges. For count number 1. The offense against the first accused person, Ferdinand Waititu Babaya, the former governor of Kiambu County, alleged that between 22nd July 2018 and 13 March 2019, he knowingly acquired the sum of 25,624,500 to stock the payments made to Testimony Enterprise Limited for the contract awarded to the said company by county government. Conflict of interest and economic crime governed by Section 42(1), 2, 3, and 4 of the ASECA, which provides conflict of interest if an agent has a direct or indirect private interest in a decision that is principal to make, the agent is guilty of an offense. If there is a situation in A and the situation in B, and there is 2 and 4. For 48, that's the penal section. In order to make a determination of that charge, the legal definition of the terms public officer and agent are crucial, so as to interpret the element for the offense of conflict of interest. Meaning of an agent is as per Section 38 of ASECA. Agent means a person who in any capacity, whether in public or private sector, is employed or acts for and on behalf of another. Status of the first accused person in the Constitution and the law is defined under the following provisions. Governor is the chief executive of the county as per Article 179(4). Is a state officer as per Article 260. He is also a public officer as per Section 2 of the ASECA and Section 2 of the Public Officers Ethics Act. In absence of statutory definition of the phrase conflict of interest, courts have resorted to the definition provided in the legal dictionary and judicial interpretation. First definition appearing in the Black's Law Dictionary. I'll not read it, you'll be able to see it. The second and definition, judicial interpretation is in the case of Bevin Wanjiro Namu versus National Police Service Commission and another. 2019 EKLR, decision by Justice Mwita. I'll not repeat it. The other definition by Justice Onyego on John Faustin Kinyo versus Republic 2020 EKLR. It is there. And bear in mind this definition, the phrase conflict of interest in the context of the present case would mean a conflict between public officers' fiduciary duty and his private interests. In applying this interpretation, the key element for the offense of conflict of interest under Section 42(3) of ASECA, which are relevant to this case, are as follows. The accused person is an agent or a public officer of a public body. Accused while an agent or state officer acquires direct or indirect private interest in conflict of his official duty in contract for the public body. Accused while an agent knowing so acquires the direct or indirect private interest in contracts for the public body. And that, I think, I'm repeating. So, those are the two elements. And the second element is what forms the mens rea, the guilty mind. Reading from the provision Section 42(3) of ASECA and the particular of the offense in count 1 for conflict of interest. For the charge to succeed, established that the public officer knowingly acquired direct or indirect private interest by receiving benefits in payment made to Testimony Press Limited for contracts awarded by Kiambu County government. In applying these elements of conflict of interest in the present case, it is necessary to prove beyond reasonable doubt that the governor knowingly acquired indirectly a private interest by receiving the sum of 25,624,500 from the payment made to Testimony Press Limited from contracts that were awarded by the Kiambu government. This is the case because the law under Section 42(3), by its purposive interpretation, prohibits a governor being an agent from harboring personal interest in contracts with this county government. The rationale in the law restricts a governor from awarding private interest contracts awarded by his county government to avert the untenable conduct where an elected state officer is unable to objectively discharge his official duties because of the competing direct or indirect private interests. Either a public officer from dedicating his whole to serve the people. A public officer must take keen interest in the affairs of the office. The Constitution of Kenya 2010 then envisages a government based on national values and principles of governance as articulated under Article 10. Under the Constitution, public officers are required to adhere to national values and principles of governance, which include good governance, integrity, transparency, and accountability. To mirror the definition, all these definitions that are meant under Section 38 of ASECA to the facts of this case. First accused person, an elected governor, was an agent of the Kiambu County government, which is a public body. The Gazette notices on the election of the first accused person as a governor produced in evidence as Ex number 47 attest to this fact. First accused person, while serving as the governor of Kiambu, indirectly through entities like Atu Estate Developers Limited and Benvenue Delta Hotel, received the total sum of 25,624,500 from Testimony Press Limited and its directors, Charles Chege Budia. Flowchart number 1, 2, 3, and 4, which I've referred above, illustrate the movement of money and payments made to Testimony Enterprises Limited from the road project tender and request for quotation awarded by the Kiambu County government into the account of the entities like Atu Estate Developers and Benvenue Delta Hotel. Additionally, under Table 1 and 2, I've also manifested a concise tabulation of payments vouchers raised and paid to Testimony Enterprises Limited in respect of the road project tender and request for quotations. The source of the funds, movement of money from Kiambu County government account, and the movement of money from the bank account of Testimony Enterprises Limited to the entities associated with the government were supported by the unchallenged evidence, which came from the following areas. 1, Kiambu County government central bank accounts, bank account of Testimony Enterprises Limited and Charles Chege Budia, bank account statements like Atu Estate Developers Limited and Benvenue Delta Hotel, testimony of the resident engineer on the road project regarding processing of the payment vouchers and attachments, if means supplier details of Testimony Enterprises Limited. The defense by the governor and the second accused and the main director of Testimony Enterprises Limited to explain the reasons of the money received by the entities like Atu Estate Developers Limited and Benvenue Delta Hotel, as well as Lake Naivasha Resort Limited, lacks credibility. I found the defense to be self-incriminating, bearing admission that Benvenue Delta Hotel, a business name, co-owned by the governor and his wife, was directly trading with the Testimony Enterprises Limited by supplying oil, petroleum products, and offering conference and catering services. Indeed, by this admission, and considering that Benvenue Delta Hotel is a business name, then the governor was directly trading with his county government. The governor has failed to rebut prosecution of overwhelming evidence that through the entities like Atu Estate Developers and Benvenue Delta Hotel in 625 and 500. This sum includes the Kenya shillings 6 million paid by Testimony Enterprises Limited to Lake Naivasha Resort Limited. The governor Then corrupt intent is manifested in the fraudulent procurement process and award of tender for the road project to Tesco Enterprise Limited. Again, the opaque advertisement of the tender for the road project without county executive committee approval, and the covert remittances of money from the bank account of Tesco Enterprise Limited to bank account of the entities like Two Estate Developers and the Venue Delta Hotel. In this case, committed with the full knowledge of the first accused person and the excuse